our next our conversation is going to be really coming from Professor Mark Bonner, who is a professor of law at Ave Maria Law School. And his talk is going to be on legal protections for the unborn babies in American civil laws. And Professor Bonner began his legal career at the U.S. Department of Justice, serving for more than 25 years in positions, including Assistant U.S. Attorney in Los Angeles and the U.S. Virgin Islands, and resident legal advisor in Moscow. For 10 years, he directed the investigation and prosecution of high-profile federal cases involving international and domestic terrorism. He subsequently joined the U.S. Department of Treasury, where he held the position of Senior Advisor and Chief of Staff to the Undersecretary of the Treasury for Enforcement. And prior to coming to Ave Maria, Professor Bonner served as Senior Advisor in the United States Department of Homeland Security's Office of International Affairs, where he oversaw the department's activities within the Group of Eight, or G8, countries. He also taught as adjunct professor of law at Georgetown University Law Center for 13 years. Professor Bonner.
Thank you, Your Eminence, Your Excellency, dear colleagues. Today I'm going to talk about legal protection for unborn babies and tie it in with some of St. John Paul's work. We're very familiar with St. John Paul, Pope St. John Paul II, at Ave Maria. The motto of our school is Fides et Ratio. And the organic mission statement of our school includes reference not only to Fides et Ratio, but also to Ex Cordia Ecclesiae. So we're very much sort of invested in the work of that great saint. Okay, with respect to legal protection for unborn babies, the major protections are criminal in nature, and I'll discuss those just briefly. They're criminal homicide laws. And I'll give you an example of two. We have 50 states, right? So we have this agglomeration of 50 states in the United States. So when I talk about a state here, I'm talking about one of those 50 states. I'll give you two examples, very, very brief. The first is the state of Alabama. And the homicide statute there covers unborn babies is as follows. Alabama Code 13A61 defines person for the purpose of criminal homicide or assaults to include an unborn child in utero at any stage of development regardless of viability, and specifies that nothing in the act shall make it a crime to perform or obtain an abortion that's otherwise legal. So you see you have a regular homicide statute that has to have plugged onto it an exception for the mother killing her own baby. But that's an example of one. So someone other than in the context of abortion kills a unborn child in Alabama, it's defined as a homicide in Alabama. And with California, let's go to the other end of the spectrum. In California, very briefly, California Penal Code Section 187 defines murder as the unlawful killing of a human being or a fetus with malice aforethought. So that's the old Blackstone definition of murder, or homicide, unlawful killing of a human, well, that's murder actually, lawful killing of a human being with malice aforethought, and adds the word fetus in there. So those are protections for third parties killing unborn babies other than the mother doing it during an abortion. Along with these criminal homicide laws are criminal abortion laws. Abortion is not, even though America has got a very bad record with respect to abortion, abortions, on certain instances, late third trimester abortions can be criminal offenses. Not well-known, well-known guy is Kermit Gosnell. Anybody who's aware of the abortion landscape in America knows that he's probably America's greatest serial killer. He's probably done more homicides than anybody in the history of the United States. He was an abortionist, and his specialty was delivering the babies and then killing them after he delivered them. And he got convicted of murder for that, but he also got convicted of a couple of dozen counts of criminal late-term abortions. So they're misdemeanors. It's kind of a pretty sorry way of dealing with killing a human being. But nevertheless, there are criminal offenses for unlawful late-term abortions. With respect to civil protections, the civil protections are not only the abortion restrictions with respect to late-term abortions or certain techniques of abortion, but also things called fetal protection statutes, which are civil suits which punish individuals who injure unborn babies or cause their death. That is to say, wrongful death, seminal suits for money damages. Think of you negligently run a woman over in the crosswalk and kill her baby. Well, if the baby's born alive or dies, you can actually have a wrongful death suit for that. There's organized opposition. The preceding speaker spoke about the torrents of money flowing into the opposition, those that support abortion. And we have that, of course, the Gates are Americans. But we also have powerful groups in America that we have to deal with respect to fixing our abortion laws. There's a white paper by one of the most powerful group, actually. It's called the American Civil Liberties Union. And they have a white paper entitled, "What's Wrong with Fetal Rights?" Well, apparently a lot's wrong, according to them, with fetal rights. This white paper says, it tells you what to do, that if you're arguing against fetal rights, it says you should ask, what language does the proposed law, the bill, employ to describe the fetus? Insist that it be free of anti-choice rhetoric, such as preborn, unborn child, or unborn human. So several of our speakers have talked about how important words are with respect to framing an issue, and that's definitely one of them. I wrote one article a while back on a child needs a champion, guardian, ad litem presentation for prenatal children. And I spent a lot of time trying to figure out, what am I going to call this human being? Am I going to call it a fetus? For some reason, that's never really, my heart has never warmed to the word fetus. Whereas unborn child or unborn baby, makes it, I think, a lot more palatable and more explicit. The landscape of fetal protection statutes is about to change in the United States, I think. Now, currently, only 6 countries in the world, besides the United States, permit non-therapeutic or abortion on demand after the 20th week of gestation. So there's 7 bad boys on the planet, 6 plus the United States. They are North Korea, China, Singapore, Vietnam, the Netherlands, and Canada. So that's the company we're in with respect to allowing non-therapeutic or abortion on demand after the 20th week of gestation. The change that is coming, I believe, is due to, among other things, the application of the doctrine of subsidiarity. And it's found in the leaked draft opinion of Justice Alito of the United States Supreme Court in a case called Dobbs versus Jackson Women's Health Organization. In that case, the state of Mississippi has passed a law limiting abortions to after 15 weeks of gestation. Now that's not an extreme position worldwide, but in the United States it is an extreme position, which is a real disgrace. But at any rate, this case is the case that's before the Supreme Court right now in Dobbs. Now, currently in my country, no state may entirely prohibit abortions. That may be coming our way soon, though. The reason no state may entirely prohibit abortion is, of course, 2 cases, principally Roe versus Wade and Planned Parenthood versus Casey. Keep those 2 names in mind, because I'm going to read you something from the draft opinion in a minute that may give you some hope. Now, with respect to prenatal protection, 38 states have fetal homicide laws, 29 of which have fetal homicide laws that apply to the earliest stages of pregnancy, using terms such as any state of gestation or development, conception, fertilization, and post-fertilization. 44 states have statutory limits on abortion. Where abortions are allowed, quote, for the health of the mother, at least, 13 states require that the physician who is making this finding file a report in writing describing the precise medical condition giving rise to the alleged need for the abortion. 35 states have valid informed consent laws, which require abortion providers to inform women of the health risks of an abortion, the probable gestational age of her prenatal child, alternatives to abortion, and any government assistance available to her should she choose to carry her baby to full term. 40 states have valid parental consent laws requiring minors to obtain at least one parent's consent or receive a judicial waiver thereof. Every state recognizes prenatal harm as a cause of action if the child suffers injury or harm in utero and is born alive. Right, so you run a woman over in a crosswalk, injure the child or give her a drug or something, and the baby is born injured because of that. If the child is born alive, every state recognizes prenatal harm as a cause of action for that child. Most states, though, including Florida in 1996, briefed by the ACLU, do not have a wrongful death cause of action if the baby dies. All right. Now, I should say our Supreme Court in Florida, I believe, has 7 justices on it. We have a new Supreme Court since 1996, and we're really blessed to have the following. One of the new justices of the Supreme Court was a student of our dean, John Czarnecki, and I guess Ron Rishlak, too, for that matter. So her legal Weltanschauung, if you please, has been formed by 2 solid Catholic scholars. One state has recognized such a cause of action where the baby actually dies, and that is the state of Alabama. So Alabama has recognized a cause of action for wrongful death against negligent medical doctors for the pre-viability death of her son. That case was Hamilton versus Scott. Its citation is 90 Southern 3rd, 728, and it's Alabama 2012. The justice who issued the principal writer of that opinion is Justice Parker, a solidly pro-life judge and quite a scholar. And he's a friend of Professor Costali. As a matter of fact, Lee is here. Organized this conference, and she has been in touch with him. He has taken several of our students as law clerks. So that's a connection we have with a very solid jurist. So civil law, criminal law, and criminal law have sought to protect unborn babies outside of and in certain circumstances, even within the context of abortion. But there's obviously a grave inconsistency between protecting the baby from third-party harm and at the same time providing a fundamental right for someone else, to wit the mother and the abortionist, to destroy the life of the baby. Enter here now the doctrine of subsidiarity. It's going to find its way from Rerum Novarum, 1891, from Leo XIII, through Quadragesimo Anno, that's Pius XI in 1931, to St. John Paul's 1991 Centissimus Anno or Centesimus Anno, take your pick, in which our dear saint wrote the following. It's well known, but I'll vocalize it here. A community of a higher order should not interfere in the internal life of a community of a lower order, depriving the latter of its functions, but rather should support it in case of need and help to coordinate its activity with the activities of the rest of society, always with a view to the common good. And Pope St. John Paul II also, in Evangelium Vitae, 1995, laid out the doctrine on the necessity of conformity of civil law with the moral law. Now, the last piece of what I want to do here is the following. It's about 2 or 3 minutes of actually, instead of interpreting what's in Judge Alito's draft opinion, I have about 2 or 3 minutes of excerpts from it so you can actually hear what this opinion is very well developed. I mean, this is a very late draft. This looks like the completed opinion. And it has internal markings making it look that way. It hasn't been officially voted on yet, so it is not the law in the United States. If one of the 5 pro-life justices should die before the vote is taken, this case will not become the law in the United States. But right now, it looks like its normal plan of events would be that it would be announced as the opinion of the court, maybe next month, pretty soon. So here are some sort of words straight out of the opinion from Justice Alito. It's 5 minutes. I'll be done in 5 minutes. This is good. It's unusual to actually have good news coming from the government on the pro-life landscape. Well, here it is. Okay, here's Justice Alito. For the first 185 years in America after the adoption of the Constitution, each state was permitted to address this issue of abortion in accordance with the views of its citizens. Then, in 1973, this court decided Roe versus Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that the American law or the common law had ever recognized such a right, and its survey of history ranged from the constitutionally irrelevant, that is, for example, its discussion of abortion in antiquity, to the plainly incorrect, that is, for example, its assertion that abortion was probably never a crime under the common law. This is flat wrong. After cataloging a wealth of other information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, much like those that might be found in a statute enacted by a legislature. Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which at the time corresponded to the point at which a fetus was thought to achieve viability. That is, the ability to survive outside the womb, although the court acknowledged that the states had a legitimate interest in protecting potential life. It found that, quotes on potential life, it found that this interest could not justify any restriction on pre-viability abortions. Allow me one parenthesis. As soon as the court said potential life, the case was over. As soon as they said that a fetus was just potential life, they slip in basically where they want to arrive at as sort of a given part of their argument. Right. At the time of Roe, 30 states still prohibited abortion at all stages. So again, keep subsidiarity in mind as I'm reading that, so I selected it for that purpose. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restricted regime on the entire nation, and it effectively struck down the abortion laws of every single state. As Justice Byron White aptly put it in his dissent, the decision represented, quote, the exercise of raw judicial power. And it sparked a national controversy that has embittered our political culture for a half-century. In the particular case at bar here, 26 states of the United States have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. In defending this law, the state of Mississippi's primary argument is that we should reconsider and overrule Roe and Casey and once again allow each state to regulate abortion as its citizens wish. I'm sorry, I'm getting emotional here, and I'll control it. We hold that Roe and Casey must be overruled. So I'll be good in a second here. That's it, good stuff. All right, all better now. Here we go. Roe's defenders characterized the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage, but abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. Okay, just about done here. It's time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. And the last piece is this here. This is the last page. And it's basically a shout out to Robert George and some other folks, so I'm going to read that to you. The Supreme Court says, we begin with the common law under which abortion was a crime, at least after quickening, that is the first felt movement of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. The Supreme Court really does, I think, honor to Robert George. They cite one of his articles, actually his brief. Here we go. Here it is. The exact meaning of quickening is subject to some debate. Compare the brief for amici curiae scholars of jurisprudence, John M. Finnis and Robert P. George, in support of petitioners. They go on to quote what he wrote. So that is pretty much the best a legal scholar could ever imagine, that in a major opinion for an important point to be cited. I would recall. All right. We also had at least two people, one person in this room, two, who also filed a brief amici curiae with the Supreme Court in this case. And the initial part, the first draft was written by Professor Castaldi, and it was polished up, and second draft by Professor Kollink. And our colleague Brian Scarnecchia, also from our school, who's in the next salon, added not only his name as professor of law at our school, but also the name of his organization to it. So we've been involved in the background there. You too, huh? Okay, there we go. We got our dean signed on to that as well, right? And everybody's, both of you guys. All right. So to finish up, the abandonment, if it occurs, of the alleged constitutional right to an abortion will remove an enormous obstacle to expanding legal protections for unborn babies in American civil laws. Thank you.
Thank you, Professor. One of the things that I've taken away from this leaked document is the fact that there's such disjointed nature in the interpretation of law. And it's something that I look forward to seeing what happens when we push it back to the states so that law is created by legislation and not by justices. So thank you very much.